So we have to keep releasing content about criminal records, what can be cleared and when. It's sort of like a tagline for us. Pennsylvania statutes are sort of complicated, but there's basically 3 ways, maybe 4, of removing or hiding records. And I just want to cover them sort of quickly here. I'll start with the most difficult first. Any misdemeanor or felony conviction has to be pardoned by the governor of Pennsylvania after recommendation from the Board of Pardons in a very long 5 to 10 year process unless you're 70. Any misdemeanor or felony conviction to be totally expunged needs to be pardoned by the governor after being recommended by at least 3 of the 5 board members on the Board of Pardons to move forward. And that will, if it's successful, completely expunge a misdemeanor or a felony conviction. Other side statutes are, for instance, limited access / clean slate. Or maybe I said that backwards, clean slate limited access. This was a statute passed in 2024. It became effective in 24 that says nonviolent misdemeanors in general and nonviolent felonies after 10 years in general can be hidden with limited access petitions if the candidate is not otherwise disqualified. In other words, if you've committed murder or have 8 felonies in your background, even an eligible nonviolent misdemeanor is not going to get cleared. So there's a bunch of hoops to go through. There's a flow chart, but in general, to keep it simple, nonviolent misdemeanors after 7 years, nonviolent felonies after 10 years are supposed to be sealed. How do they get sealed? The clean slate part of the statute, it orders or instructs the Administrative Office of Pennsylvania Courts and the Pennsylvania State Police to create this computer algorithm that runs through the State Police criminal repository and finds eligible candidates, and it's supposed to seal them. For instance, non-convictions are supposed to be expunged when they're non-convictions. Nonviolent misdemeanors after 7, nonviolent felonies after 10. It's supposed to go through and find these and hide them or seal them with clean slate. Sometimes it works and sometimes it doesn't. And so the flip side of that is limited access. Limited access is the part of the petition where an attorney talks to a client, and if they believe they're eligible for limited access petition, they file a petition in the Court of Common Pleas and get it in front of a judge and a district attorney. And if it is an eligible candidate who's filing limited access on appropriate charges, then the judge will sign the order. That order will go to the state police and will tell them to seal the record. And what sealing means is that when people do background checks with the state police, if a record has been sealed, they should not disclose it. If there's a record on the same guy's jacket that hasn't been sealed, then that record would continue to show up. And by the way, every record that's sealed, whether with clean slate or limited access, needs a pardon, because the only thing in general you would be sealing are misdemeanor or felony convictions. And we already know from the first part, you need a pardon to expunge them and get rid of them completely. All right, solution number 3, expungements. Expungements are what actually clears the criminal record. Expungements are an order from the court that tells the state police to go into their repository and expunge that record as if it never happened. It allows the candidate to deny they were ever arrested or convicted, and there should be no record that should be locatable. And so that's what the expungement does. What can be expunged? The expungement statute is very small and limited, and the answer is, if you're 70 and you've been out of trouble for 10 years, expungement can even get rid of misdemeanor and felony convictions. Otherwise, you would need a pardon. Number 2, summary offenses, which are the smallest offenses you can have. Summary offenses after 5 years of law-abiding behavior can be expunged. Underage drinking. If you turn 21 and you're over the age of 21, you can get an underage drinking summary offense expunged, whether it's 5 years old or not. Juvenile cases. A juvenile case is eligible in the county of disposition if you have not received an adult conviction after that. A juvenile record is eligible to have a petition to expunge it filed no matter what the grading of the offense. The attorney would file it, the district attorney would weigh in, the judge would make a ruling, but in general, juvenile records are expungible. ARD is a way of handling many cases like DUIs, where you get ARD, which is an alternative or accelerated rehabilitative disposition. It's probation without conviction. It feels like conviction because you're doing probation, but it's not a conviction. If you do community service, you do your alcohol highway safety programs, you complete all your terms and conditions, pay your fines and costs, then at the end of that ARD, when it's successfully completed, you can have that DUI or whatever else it was expunged, and it goes away as if it was never there. Finally, anything that's been pardoned by the governor can be expunged. So the expungements would clear the records. You get to the expungements different ways. You either get to the expungement because you're eligible under the expungement statute, very limited, I just covered it, or you get to the expungement statute because you're not 70, but you file a pardon on misdemeanor or felony convictions, and when you get the pardon from the governor, you can jump to the expungement. So, hope that all made sense, and if you have any questions, just write a comment or tell Anna.